People v. Garcia.
Good afternoon, Your Honours. David Fitzmaurice from Appellate Advocates for the appellant Kenneth Garcia. I'd like to reserve 3 minutes for rebuttal.
Yep.
Your Honours, when the prosecution show that a show-up happened close in time and place to the incident, that's only the first half of their burden at the Wade hearing. The second half is that they also must show evidence that the procedure itself was not unduly suggestive. So basically, they must explain kind of what steps were taken to reduce suggestiveness or why no such steps were possible.
And what law are you citing for that proposition?
So I think that dates back to, that's a combination of Chip and Riley. So I guess the must provide evidence demonstrating that the procedure was not unduly suggestive. That's a direct quote from Chip. And then the must explain what steps were taken. That's a quote from this court in Riley. And I think these standards are pretty well settled. Which is why this case, isn't asking for anything extraordinary or new or novel. It's just asking for those standards to be applied, because when those standards are applied to the undisputed factual record here, we see two extremes. We see one suspect who they have an adamant, definite, detailed description on and on, over and over, very sure about one person, and then we have my client, Kenneth Garcia, for whom they have virtually no description other than him being Hispanic. So applying these well-settled standards to this undisputed factual record, I'd submit that the burden at the Wade hearing is to show what steps were taken to ensure that the identification of Kenneth Garcia, my client, didn't simply flow from the evident familiarity between the complainant and Louis Garcia.
Did you make that argument below about the collective nature of the procedure, or were you just arguing that the fact that they were flanked by police officers spoke to the suggestiveness of it versus the collective nature of it?
No, I think that the argument below has always been that bringing the argument below has always been that the lack of specific description for Kenneth Garcia and the fact that they're brought out together with no one else present, and how there was other steps that could have been taken to reduce that procedure and weren't taken. So I think that...
Well, that's not the testimony, is it, that there were no other people present?
No other people were escorted out by the officers. That is a testimony. You're right. I think what Your Honour is getting at is that there was a crowd present, absolutely. And I think actually, when we think about a crowd, we actually think that that's a potential way that this could have been ameliorated. For instance, while officers are upstairs in the apartment and there's a crowd gathering, I don't think it would be too much to ask the complainant whether anyone in the crowd looks familiar, which I think is something that, a few months ago this court in Wright had a show-up situation.
What was to stop the complainant from looking around at everybody that was out there and point out someone else?
Nothing would stop the complainant from doing that, but I think that this is a police-controlled...
And isn't that better? There were people around. This isn't one where they take them to an isolated area where there are no other civilians around. People were coming and going. There was activity. And quite frankly, though, when you have a show-up, isn't there suggestiveness always present? You're right,
there's inherent suggestiveness in every show-up. The police are necessarily going to be involved in every show-up. There's going to be an assumption that the police are conducting a show-up with someone who they probably think meets the criteria. But I don't think the crowd here cuts in the prosecution's favor, because we don't know any information about who was in the crowd, do they match the descriptions. And actually, I'll note that at the suppression hearing, there was an attempt to cross-examine the officers about the crowd and whether there was any effort to ask questions about anyone else, and that was objected to and sustained. So we don't have a situation where in Wright, prior to actually getting to the show-up, this court was able to point to the fact that the officers had asked the witness whether other people were familiar along the way and had elicited negative identifications. So we don't have that here. What we have is we have a situation where we have two extremes and brought outside together, and I submit that faced with the burden to show steps they took to reduce the suggestiveness by putting everyone together surrounded by officers, they're actually showing steps in the opposite direction.
What is the relief you would want here?
Well, I think the relief, since this is an issue that was raised at the Wade hearing with no independent source, there's no There was no subsequent lineup. The relief here is dismissal. The relief here is absolute dismissal.
Why is the relief not a remittal for a independent source hearing? And there was in-court identification, yes?
There was, but at what stage, Your Honor?
At trial.
At trial, there was but I think that would be tainted by the unduly suggestive show-up. So if we're analyzing
How do we know that?
how do we know that it was tainted by the unduly suggestive show-up? Well, we know that because there wasn't much information at trial other than the fact that he was identified in the show-up. There was a lot of information about the co-defendant for whom they had an adamant, detailed description. There was video evidence of that co-defendant. There was video evidence of him standing outside and going inside. There's not a single piece of video showing Kenneth Garcia leaving that building or coming back at any time that day. So when we think about the taint of the show-up on the trial identification, we actually learn a few details about the show-up, a few additional details, including the fact that the complainant's brothers are all of a sudden present and shouting while the show-up's taking place. So I think that we should take no comfort in the fact that the trial ameliorated any of the problems associated with the unduly suggestive procedure. I think that when we have a situation where...
So is it your position that at any time there's more than one person who's going to be identified by a witness, that they cannot be brought out together regardless of the circumstances that the police face in the moment?
No, that would not be my position, and I think this area of law doesn't easily lend itself to kind of per se rules. My position is just applying the burden at the Wade hearing and analyzing whether there are steps in the record showing efforts to reduce suggestiveness. When we have a situation where one suspect is completely detailed, familiar, and then,
Does it matter here? There were no guns drawn, people weren't handcuffed.
No one's in the back of a car.
no one's in the back of a car, there's no guns drawn, there's no handcuffs, and that's because there was no arrest. So we often...
And timing-wise, with respect to identification, does it matter that it occurred rather quickly?
So there's two questions. I'm going to get to both of them, right? So I guess the timing thing, I think there's no dispute that when we think about timing, we think about that it was reasonable for them to do a show-up instead of a lineup, and that's not in dispute here. I submit that under these circumstances, it is reasonable. It's about an hour later, it's reasonably close, it's a few blocks.
But I mean the timing of them even coming out.
So,
It
yes.
wasn't that they were standing out there for a long period of time.
It's not, no. But I think that when we think about the absence of the cuffs and they're not in the back of a car, it is important to note that they're not under arrest. So when we think about situations where suspects are arrested, a lot of the time the argument is, well, there were cuffs present and that tainted it, and sometimes it does and sometimes it doesn't. But I don't think an officer's decision to not put cuffs on someone who's not arrested can be now credited as a way they reduce the suggestiveness of the procedure, when the suggestiveness of the procedure is because there was a risk that the identification of someone who they had a lot of information about would flow
Well,
and taint.
would you at least concede that it reduces the suggestiveness of the procedure if you accept Judge Troutman's earlier premise that there's activity in the area, they're just sort of blending in with everybody else walking around who doesn't have handcuffs on and isn't formally under arrest. They're just part of the street scene.
I'm not sure the record can support that. The record shows that there were 5 officers inches away. So while there are no cuffs, I think it's very clear that they were escorted down by 2 officers. They met 3 officers then at the bottom, and then the show-up is happening. He's asked does anyone look familiar? Only when there's this cluster of people clumped together within inches of each other. So I don't think this could be confused for just passers-by. It's not. This isn't a.
Well, are they being restrained in any way by the?
They're not constrained.
I mean, there was a question asked from the judge, I'm looking at page A389, and said, of the complainant, were you able to tell who was walking out with officers and who was just walking out themselves? And the witness said no.
So I think
that cuts against your argument that it was only when they figured out that the people who came out with the officers were the people that he needed to identify. He's saying there were people walking in and out of the building, and I couldn't even tell who was with the officers and who wasn't.
So I think what Your Honor is quoting is the trial testimony.
Yes.
That fact is not established at the hearing, where they have the burden to come up with these facts. I mean, we talk about burdens, not to be pedantic or to have some kind of formalism. We talk about burdens because the police and the prosecutors are the only ones who know what happened. So if a situation like that, if that kind of testimony came out at the Wade hearing, it might be slightly different.
But I thought at the hearing, the testimony indicated, maybe I'm conflating it with the trial, so tell me if I am, but that they went upstairs and asked whether or not they preferred to speak outside of the presence of the family. And I thought that the officer who escorted them down the stairs said that he was not in contact with the officer who was outside. So it wasn't obvious to me from the record that the intent was to take them down for a show-up as opposed to take them down to continue the conversation they had begun upstairs.
So I think, Your Honor, he admits several times at the Wade hearing that he had instructed the complainant to remain with the officer outside, and that when he went up with the purpose of speaking to them, canvassing, and also to conduct a show-up.
But I
He
thought
said
there
it
were
multiple
two
times.
officers, right? I thought one was downstairs with the victim, and I thought that the person who, I forget the name, perhaps it's Anderson, but you'll correct me.
Anderson's downstairs, Boyce is upstairs.
Voices upstairs. I thought that the officer who escorted the individuals downstairs said that he had not, he was not speaking at the time with the officer who was downstairs. I'm just asking whether it's apparent that the purpose was to take them down for a show-up as opposed to have a conversation, and whether that matters.
It was, and actually, the officer downstairs maintained that no show-up happened, and she tried to quibble with the definition of a show-up. But the officer who went upstairs, Officer Boyce, did testify that he went upstairs with the intention of conducting a show-up, knowing that he had instructed the complainant to wait downstairs. So while he didn't necessarily radio, that doesn't excuse the fact that, when he went into the, I know my light is on, but when he went into the room and he saw someone who matched the detailed and adamant description, and then he saw someone who just really only met the description of race, alarm bells should have been ringing on his way back down, because he's in control of the situation. They're not under arrest. There's no cuffs. He's in control. They're cooperating. He should be thinking, and we want him to be thinking, there's a risk that if I put them in a group, that an identification of familiarity can flow. And Wade instructs us, the Wade hearing and the two-part burden, it instructs us that these are the kind of things that that officers should be sensitive to, and prosecutors should be trying to establish.
You mentioned that they instruct the victim to wait
Yes.
while they go upstairs. Is there any statement of what's the intent of going upstairs?
I mean, the intent is to canvass. It is to look for the suspects. This is a police activity.
Based on what the victim told them?
Absolutely, yeah. And the victim was able to point them in the direction of the building, and he is canvassing, and he's meeting people, and he gets a tip, and he gets a second tip, and he goes upstairs, and he sees the three people, and he decides to bring them back down.
What the victim communicates is that at least one of them went upstairs.
Yes, yeah. And there's no, so the victim does a lot here. He points them to the direction. So they are looking for suspects. They are about to do an identification procedure, and he brings them downstairs knowing that, yes, he'll get to talk to them, but also that an identification procedure
But
can
your
happen.
reading of the record is that the victim understands that is the process that is occurring.
I'm not
not.
sure. I don't know. Well, typically the prosecution don't call the complainant
No, I
at
know
Wade
that.
hearing,
I
so it's hard to
understand
know. But yeah, I mean, I think when he's talking to multiple different officers and he's giving a description, he's adamant on and on and on and on, and then when the officers go in and they see somebody who not only matches the description, but he's changing his clothes and he makes a statement, and then there's a decision to bring them back down. That's what I submit. We want officers in that situation to have alarm bells ringing that.
We've said in places like Howard that far more suggestive circumstances of an identification are okay. So how would you reconcile that?
So I think Howard, my understanding of Howard, I'm not quite sure. My argument here is very narrow. It's about an initial burden not being met. I'm not sure the suppression hearing record in Howard, at what stage an initial burden was met and then transferred over to the ultimate issue of suggestiveness, which would be a mixed question of law. I know one of the issues in Howard was about there was an argument that the time was per se unreasonable. It was too long. So that's not an issue here. And I'll also note in Howard that they did find the complaining witnesses' wallet and identification. So there wasn't really the same risk of misidentification. They had a lot to go with, whereas here, we really have a situation where someone's brought downstairs, cooperating, not under arrest, you know, and volunteering to come down with no incriminating evidence. And I think in that situation, we want officers to be thinking, and we want prosecutors to be asking, you know, how did you reduce the suggestiveness, or how did you
How do
explain?
you suggest they would have reduced the suggestiveness? Do you think if they had brought them out one at a time, each escorted by an officer, that would be more or less suggestive?
Well, I think that would be less suggestive. Well, by the way, I would submit that it would be at least a step in the record. So we might be in the situation where the burden is now shifted to the defendant to argue, and then that's a mixed question for this court. But if that, let's say, Your Honour's hypothetical, let's say they did separate, which is something that the prosecution conceded below that they could, at least we'd avoid a situation where the identification is, that's them, that's him, the guy in the yellow shirt, he cut me. You know, that kind of identification couldn't happen if they were brought out separately. And I'd submit, since they had so little information about my client, Kenneth Garcia, if he comes out first, then there's no risk that familiarity with Luis Garcia or anybody else is tainting his identification, because we're not having the situation where it can flow. He's coming out first with one officer. So in that situation, it's a very different record.
Well, yes and no. I get your point that perhaps it's not the obvious association, right, because they're together, as the three attackers were. But obviously, if you're strolling out three people in a row, it does influence the thinking potentially of the victim that these are the three.
It does, but
Because there's no one after the third one.
It does, but I think we're back to the land of show-ups. Show-ups being inherently suggestive, and a certain degree of it is tolerated. So because we tolerate a certain degree of it, we just want some effort, we just want some testimony about how they tried to do, you know, make it a little bit better. So in this situation, yeah, maybe it still would be suggestive. Maybe a defense counsel would still argue, but there'd be a step.
What if the officer had testified? It's a hypothetical, I know it's not in the record. Had testified, well, we thought about it, but we thought that would be more suggestive, one at a time.
I'd actually thought about that question myself.
Okay, good.
Yeah, it's a good hypo. We obviously, you know. So I think in that situation, we would at least have, you know, some testimony record where, in line with that second step of the burden, there is an effort to show what steps were taken or that none were possible, you know. So in that situation, it might not be unduly suggestive if the officer's saying, well, it was 6 in one and half a dozen in the other. Well, then we don't have a situation where there's no effort made and there's just kind of an indiscriminate collective show-up, even though they know that they have two very different suspects inside it. So in that situation, not that we should be hinging on...
If that calculation is based on something any member of this court could also make, then why can't this court do that?
Say that again?
If that calculation, 6 of one, half a dozen of the other, is something that's simply based on, well, if they're one at a time, that's, if not more, at least as suggestive, right? It's sort of that kind of thing.
Because we...
Couldn't a judge just come to the same, I mean, all I'm saying is there's some particular expertise that's necessary to weigh that.
I understand exactly, but I think we should be very reluctant to be putting words in prosecutors' mouths when we're talking about the initial burden. I mean, like I said earlier, they're the ones with all the information. They're the ones who've talked to the witness, talked to the cops, talked to, you know, prosecutors. You know, the defendant does not know what steps were taken or what steps were possible or how, you know, let's say hypothetically there's a situation where there's a police procedure and there's an optimum ratio of officers to suspects in a show-up, you know. That's something that would need to be said, because a defendant, the defense counsel won't know that. So we have an initial burden because otherwise we're in the dark. And I think the fact that we hear so many shifting positions on appeal, whether that's not police controlled or agency or yes, they could be brought outside, no, they couldn't be brought outside, you know, the fact that we can't show where in the record a step was taken to reduce the risk that Kenneth Garcia was identified because of the complainant's obvious and accepted familiarity with Luis Garcia, and that to me I think is why the Wade hearing here, the prosecution, you know, it's unusual, but they didn't carry their initial burden on these facts. And if there are no other questions, I'll sit down.
Thank you.
Thank you, Your Honors. May it please the Court, Chris Coasler for the Office of Melinda Katz, Queens County District Attorney for Respondent. So just to start with preservation, all the claims they're raising are unpreserved. They never raised anything about the group nature of the show-up. They never asked for some special rule regarding group show-ups, to wit that we have to show why it was not possible to do this in a sequential manner and why the police did it in a group manner. That claim never came up. So that's entirely unpreserved. And if you're going to argue for a new rule of law, you kind of should raise it before the hearing court in the first instance and have that court consider it. That they failed to do. This is really a little more than a mixed question of law and fact. It's been considered by this court on previous occasions, in Howard, Cedeno. As long as there are record facts that support the lower court's decision, this court is compelled to affirm. As far as the burden goes, our burden has been called by this court minimal. That's in Ortiz. We have the burden of producing some evidence relating to the show-up itself, not all evidence, not explaining every last thing that the police do, in order to demonstrate that the procedure was not unduly suggestive. This court further said the people's procedural burden of production in this respect is minimal. It requires merely some proof of the circumstances of the on-site identification procedure. We don't meet that burden where there's a complete absence of proof addressing suggestiveness. So we just have to produce some proof. We don't have to explain every last thing that the police do, why they didn't do this, why they didn't do that. It's different in the context of a precinct show-up.
So how did you meet the minimal showing here?
By showing a lot of the things that we've already discussed. There were no cuffs, there were no restraints, they weren't in a police car, they weren't being held, there were no suggestive gestures or words spoken by the police. There were other civilians around at the time of the identification. All these factors are factors that this court has considered in other cases, like Howard, like Duvon, long line of cases.
Well, that's just listing everything that was not done. Without, yes, and I think you're right, that does indeed present some evidence, but it doesn't address the suggestiveness of what was done.
Well, I mean, it kind of does, because that's what's been done in every single case that this court has considered. It's basically a series of negatives. We affirmatively show a series of things that were not done. The only things that they argued below were that the presence of the police and the lighting conditions made this show-up suggestive.
Did you argue exigency below?
Well, we elicited evidence regarding exigency. When the prosecutor made her arguments, she relied mostly on time and place.
But before the suppression court?
Before the suppression court, she elicited
She elicited testimony, but
Correct.
didn't utilize it as an argument.
It didn't come out of the argument. She relied mainly on time and place, that it happened within an hour, 3 to 5 blocks away. That doesn't mean that the appellate division reached something that it shouldn't have, and I would cite the People v. Nicholson, 25 New York 3rd, where the court gave a general ruling that our presentation of a rebuttal witness was, quote, proper rebuttal. And the prosecutor's argument was to show that the defense witness had lied. On appeal, the appellate division said, oh, the witness's testimony was proper, but it went to bias and motive. So the argument made before this court was, well, that's a different ground. You can't do that. And this court said you can look to the entire record, the arguments of counsel, the decision of the court below, as well as any inferences to be drawn therefrom, in order to reach the unarticulated basis of the court's decision. And here I think you can do the same thing.
So suppose straight ahead of you. Suppose defense counsel at the suppression hearing had said exactly the argument that's being made now, right? One person, highly identified, yellow shirt, all these indicia. Other person, nothing about, and this is inherently suggestive because you've got you bring 3 people out, you made that whole argument. Would you meet your minimal burden by saying it was light out and there were no handcuffs?
Well, I think we did more.
What I'm asking, right, does the minimal burden have to meet whatever the argument is made?
Well, I mean, it's not really our burden to show. I mean, there's no case from this court that says it's our burden to show that why they did this in a group fashion rather than sequentially. There's a single observation that this court made in Adams, and when this court stated in Adams with respect to a group show-up that took place inside a precinct, so there was a lot of other suggestive factors going on. It wasn't just the group setting. What this court stated, just want to quote the exact language. So from Adams, this court stated, showing these suspects together also enhanced the possibility that if one of them were recognized by the other victims, the others would be identified as well. And this court said that hinged on the fact that one of the defendants in the show-up was arrested at the scene, so the victims saw him being arrested. The The other one got arrested hours later. Here we don't have anything like that. He knew Mr. Garcia, that's Luis Garcia, from a previous occasion, not affiliated with the crime. Just he saw him in the street a couple of times, basically. So there's no factor here that says that there was some suggestiveness as to, you know, one of the defendants' involvement in the criminality that would have made him identify the others. And there's certainly no
Other than
reason.
by association, because he doesn't have any description of this defendant, right? Other than he's a Latino male or Hispanic male, excuse me, which there's a lot of people who fit that particular description, right? Doesn't help you that way. But even if they wanted to bring them out in that cluster, why not bring out the one that hasn't been described first? That way, it's not someone who's associated with the one he over and over says, that's the one who attacked me, that's him, right?
Well, I mean, it's kind of hard to expect the police to parse all this out during a show-up, which is supposed to be prompt. You know, you had a victim
No,
there.
but they're in the apartment, they're taking time to walk down the stairs. I'm not saying there's not urgency, I absolutely understand your position on that.
Right.
But they are making a decision about how to come out of the building.
I really don't know that this was like a conscious decision to just present them like that rather than sequentially, because there's nothing that shows that that is less suggestive. Again, it's just that line from this court and that one decision involving a precinct show-up, not an on-the-scene show-up. So, you know, I think it kind of defeats the purpose of a show-up, which is
Isn't it
supposed to be.
common sense if a victim can clearly articulate a description of one person, because they're the attacker perhaps, and has a little bit of a description of another one, but not much on the third. It's a nondescript description. I mean, it's not going to help you. Lots of people on the street fit that description.
No, sure. I mean,
Yeah,
it
right?
was a
If you-
general description.
And it's numerical, it's three of them.
Right.
And you bring out the three together with the one who seems to really fit the description, and another one that, you know, 1,000 people fit that description. It's not nondescript, but perhaps there is a likelihood that the victim might in the moment identify them by association as opposed to based on what is their recollection of that person.
But I mean, the officers testified that the victim identified everybody by their roles in the crime. Said Mr. Garcia wearing the yellow shirt, Mr. Luis Garcia was the one who
Yes.
cut him.
Yeah.
And he said the other two were the ones who were kicking and punching him. So that's still
Well,
a
the
little
other two
general, but still,
the other two
he's
attackers
parsing it
are doing
out.
the following, but that's not about identifying the attacker. That's just identifying the role of whoever was the
Right.
attacker.
Can
Right,
I
but
just
that-
explore the details of that last thing? Because my understanding, please correct me if I'm wrong, is that during the initial encounter with the police, he described what the assailants did. One cut, others kicked, or whatever they did.
Yeah, correct.
But then at the show-up, my understanding was simply that the identification was something along the lines of, that's them. Did the victim actually say those people, at the identification, did the victim actually say, that guy is the guy who cut me and the other ones were kicking me and beating me?
Well, what Anderson testified to, I just want to read this quickly. Yeah, what Anderson testified to was that he stated, those are the guys that jumped me. And then he referred to Mr. Luis Garcia with the yellow shirt as stating that he is the one who had cut him and that the other two kicked and punched him. And
That's
from
what he
An-
said at the show-up.
That, according to Anderson, that's what he said at the show. That's what he said. It's true that the description, just to get back to what we were discussing about the description, it's true it's a general description, but we have to contextualize it a little bit, I think. Because this victim was found right there in front of the building. The police encountered him. It was a pickup. It wasn't like a 911 call. And he said, they went in there, this is what they're wearing. There's no indication in the record that they had to get more of a description from him, or that it was necessary, because Boyce went to the front door, encountered somebody, a woman who said, yeah, my brother just got into something, and there was a resident of the apartment in front there that let him in. So this wasn't like a widespread canvas where you would need more of a description. So it's
Yeah,
reasonable.
but isn't that in part the point? I'm not sure you're making really your point there. It just goes to sort of the train has left the station. I found three people, one of them fits the bill, these other two likely are the two who are with him. Whereas the other two may have been somewhere else in the building, or maybe just the person who is this third person who is identified later on as a defendant is somewhere else, or in another apartment, or next door.
Well, there are all sorts of possibilities,
There are all
but we don't have to produce evidence disproving every possibility of something that could might have in some, view of
No,
the
I'm
evidence
just
have
saying that
occurred.
that's the concern, right? That's perhaps the concern, that it's by association when you have such a limited description that it's a non-description. That if that's all, let's say it had just been one person, for one moment. If that's the only description, the one that's attached to this defendant, if the victim had given that description, the police are not finding that person anytime soon.
Well, I mean, if they have the victim standing in front of the building and said he went in there, and they
Yeah.
encounter his sister, and the
And
guy who
50
lives there
Latino
lets him
men
up
of
there.
that age live there,
Excuse me?
and 50 Latino men of that age live there.
Well, according to the
How's that
record
gonna
that we
help?
have, that's not true.
Well,
According to the record we have, that's not
I've given you the
true.
hypothetical about the point about the association, right? That's the concern.
Right,
of the
right, but I mean,
suggestiveness.
sorry, go ahead.
No,
I
no,
mean
but
to
that's the
interrupt you.
concern about the suggestiveness.
Yeah, but I mean, again, I can only address the facts of this case. There weren't, according to this record, there was just 2 women and some children in that apartment. These were the only males in the apartment. So it's not an apartment where you got 50 people in there. And I still think it's pretty.
How long after the actual attack are they in the
It was less
apartment?
than an hour. He was ID'd less than an hour after
Mm-hmm.
the attack, about 50 minutes, let's say, okay? But, they were the only 3 found there.
Mm-hmm.
And, the rule they want here about, quote, explaining everything, again, that applies to precinct show-ups, because there we have to explain, well, why'd you conduct a show-up in a precinct rather than a lineup? That rule has never been applied in a setting like this, because precinct show-ups are different. They involve this extreme degree of unreliability. This court has never said that a group show-up has an extreme degree of reliability, because it just doesn't. It's just one more factor that goes into determining whether the show-up was not unduly suggestive. All this court said in Adams, which again is a precinct show-up case, what all this court said was showing the suspects together enhanced the possibility that if one were recognized, the others would be identified. It didn't say anything like it said in Riley, which is a precinct show-up case, a pure precinct show-up case, but also one that had a group showing, 2 people were showing at the same time. In that case, this court stated, unreliability of the most extreme kind infects show-up identifications of arrested persons held at police stations. So in a situation like that, we have to put forward evidence as to, well, why did the police do a show-up in a precinct instead of a lineup, right? And when we don't, in Riley, the evidence, there was no evidence of that, because the police mainly said, well, the lineup room was being renovated. And they said, well, we just wanted to do it quickly. Well, that's not good enough.
Do you think it would be unreasonable for me to think that if I were 45 years younger and were brought out instead of Kenneth Garcia, I would have been identified?
If you were brought up instead of Kenneth
I'm
Garcia.
too old now, but yeah, if I were 19.
I mean, if you have a picture of yourself from, all those years ago, maybe I can take a look at it and give you an answer, but I have no idea what you looked like 45 years ago.
Fair enough.
But, the description wasn't exactly 100% bare bones. It wasn't specific detail down
What
to
else
like,
other than Hispanic, sorry, Hispanic male
Late
in a
teens.
particular age group?
Right,
What
late
other
teen-
than that?
late teens to early
I
20s.
got it.
One of them
Other-
was wearing a yellow
right.
shirt.
No,
Right.
no,
Not the
about
other
the
two.
one that's identified as a defendant.
As to him,
Yes.
well,
Yeah, what is
one of
that?
them was identified as heavyset. And when
Right.
boys
That's not
went to...
this one.
No, this defendant.
This defendant was
Well,
identified as
not
heavy
so much in the description. 3 of them, I mean, he's describing all 3. That describes them
yes.
as, again, 3
Yes.
Hispanic males, late teens, early 20s, one of them heavyset, one of them wearing a yellow shirt. They go in, and Boyce, during his testimony at the hearing, described Mr. Garcia, not Mr. Luis Garcia, as heavyset. So it had that one additional added detail. I would point out, though, that in Howard, it was a pretty general description as well. The only description was a certain number of African-American males wearing hoodies inside a gray or a silver Honda. When they found the defendants, I think only one was wearing a hoodie, and it was a Pontiac. So, cases sometimes have variations in description. Still, this court found that that was a mixed question of law and fact, and that the record supported the hearing court's determination. These descriptions, because there could be all sorts of reasons why you don't have more of a description. As I said before, maybe the police just didn't ask because they didn't have to, because they were right there. They were going in the building. There's no need to get more of a description. If you know where you're going, you got guidance up to the apartment, you know that the people who you are looking for might be there. This is not a case of a widespread canvas, all right? So, but again, our burden is very minimal. There's absolutely no law, no science whatsoever that says doing a group show-up is more suggestive than a sequential show-up. You can have a sequential show-up, first person gets ID'd, and the argument's going to be the same. Oh, well, that led them to identify the next person. That made it suggestive. There's no distinction between the two that says one is the proper procedure rather than the other, such that you have to explain why you did this as in a...
But it might be more suggestive to start out with the one who is more vividly remembered by the defendant, as opposed to the one where all you've got, at best, I'll give you the heavy set, is Hispanic male of particular age range who's heavy set.
Start out meaning bring
Yeah.
him out, bring
Yes.
out Luis Garcia first?
Correct. Yes.
I mean, but then the argument's going to be, well, he knew him well, so then that led him to identify the other two, you know? I just don't think a show-up is really amenable to all this, you know, this amount of planning, because it's supposed to be prompt. You know, you got a victim, got the ambulance there. The police didn't know the extent of his injuries. You know, he could have had brain trauma. They actually did, if you look at the medical records, they did a CT scan, I think. You know, thankfully, he didn't have that trauma. But they're on the scene when the police have a victim who could have all sorts of injuries, you know, who knows what's wrong with him, standing there and saying, you know, should we group them together, or maybe we'll bring this one down first, or, you know, maybe we should bring the other one down first. It kind of defeats the purpose of doing a show-up, which is supposed to be prompt, close in time to the crime, done as quickly as possible so you can ID the perpetrators, you know, find the weapon if there is a weapon, allow the victim to get to the hospital to get the treatment that he needs. And that's how the police performed the show-up here, and that's why it wasn't unduly suggestive. There's no need, therefore, to create a separate rule, like the rule that you have with precinct show-ups, which are, you know, per se, infected with extreme unreliability. That just doesn't exist here, and there's no law or science that says otherwise.
Thank you.
Thank you.
Counsel, can I ask you to clarify your view about what the people's burden is? Is it that the people have to establish what happened at the show-up, the circumstances, so the court can assess whether there was undue suggestiveness, or are you taking the position that the people have to demonstrate that specific steps were taken to minimize or reduce the suggestiveness?
So the people's burden actually applies across all police-arranged identifications. It certainly isn't limited to precinct show-ups. Chip actually, I think, might have been even a lineup case. So the burden is reasonableness, establish reasonableness, and then make an initial showing, not the ultimate showing, but an initial showing of a lack of undue suggestiveness.
I understand that, but does that require, in your view, the people to demonstrate, to put on some evidence about what happened in the course of the show-up? Or are you, I just couldn't tell from your brief, are you taking the position that the people have to show, I took the following steps in order to minimize the suggestiveness?
I think it's a little more than just describing the show-up.
So is your position that they do have to show specific steps to minimize suggestiveness?
I think that this court has articulated, show what steps were taken to reduce, and I think that language is applicable here.
And where in your cases, in our cases, do you see some requirement that the people show they took specific steps, as opposed to elucidating the facts enough for the court to gauge whether it was unduly suggestive?
Well, I think it stems from the fact that the starting point is it's a suggestive procedure. It's an inherently suggestive procedure.
Right, I'm just asking if there's any specific cases that you could point us to that require that.
I just think that in this situation we have whether it's Riley or Adams or Gordon, we have steps going in the opposite direction. We have steps, making things more suggestive instead of less suggestive. So this is kind of an unusual situation because I agree, this is a minimal burden. It should have been very easy to meet in this situation. Police are in total control, cooperation, no arrest. if there's ever an ability for police to arrange, and cater to make sure that an identification isn't duly suggestive, it's when an hour later they have people who are voluntarily leaving an apartment to come outside. So this makes it very difficult from the situation where it's a continuous chain of events.
Counsel, this argument about steps implies a certain amount of intentionality in putting together the show-up. And your adversary argued a few moments ago that these are kind of fluid, evolving situations. You could have an injured victim. You don't, maybe Officer A doesn't know who Officer B is bringing downstairs, whether it's one, whether it's all three of them. And I think his response to that was, what you end up with is a situation where you have to show what didn't happen, because it's too hard to show, or maybe even impossible to show that level of intentionality, that we made a plan.
Absolutely. You couldn't.
Do you accept that?
I absolutely accept that. And I'll even go one further. I accept that there are certain situations which are so time sensitive that not only is a show up appropriate and reasonable under step one, but actually we actually do apply a kind of discounted version to step two because it's a continuous chain of events. So let's say in Duvon, where there's only 2 or 3 minutes between all happening, this court doesn't want to come along, no court wants to come along and say, well, in that 3 minutes, there was this 30-second period where you could have taken a step. So we already apply that discount in true exigency, continuous chain of events cases. And if there's one thing I can impart in this court is that this is the exact opposite situation. It's a situation where a show-up, yes, is reasonable, because it's close enough and it's prompt enough, but that can't end the inquiry. And I think what we're having is a situation where everyone stops at promptness. But we already, true promptness, 2 minutes, situation in Wright, they arrive in Wright and he's still at the scene and then they chase him. I mean, we know what true promptness looks like. We accept a kind of a discounted, consideration for due process in that situation. It's offset. We have to know this couldn't be further from that. In Wright, a few months ago, this court found it to be a mixed question because it looked at the record and it said, even though they arrived at the scene minutes later, saw him still at the scene, and he fled, and they're chasing him, so it meets every definition in traditional sense of promptness and exigency. They still asked whether other people looked familiar, and they still brought to do separate show-ups. So they were still, so this idea that I'm looking for a perfect show-up and a perfect list of every exclusion, absolutely not. I'm looking for them to come in and articulate something on the record that is attentive to the risk that when they have this extreme situation of someone being so familiar and someone being so vague, that in that situation, there has to be more than just, well, we didn't cuff him. Particularly when they're admitting that the reason they didn't cuff him was because he hadn't been arrested. So it'd be different if they even said, we didn't cuff him because we didn't want to bias an identification. So we really just have, it's as if this record doesn't have step two at all.
Can you tell us what you would have wanted them to say?
What would I would have wanted who to say? What I would have wanted
To justify the lack of suggestiveness in the show-up procedure used?
What I would have wanted, I would have wanted, you mean they being the police officers?
Yeah.
I would have wanted the prosecution to elicit testimony that there was some timing component that couldn't happen, or that there was some moving fact on the ground, or something that was at least attuned to the risk, because this isn't a new risk. These cases, yes, they might have happened at precincts, but they're 30, 40 years old. The idea that if one witness is more familiar, it can affect the identification of a second witness. This isn't new for police to know. We expect them, Duvon actually has I think it might be the final paragraph of Duvon. It has a very interesting part from this court where it talks about how it's directed straight at law enforcement. It says that we have these burdens so that law enforcement specifically will know that their evidence-gathering process, quote, won't be tolerated if undue suggestive procedures become routine. So we are doing this with an eye to influencing prosecutors at hearings that then trickles down to police in real time. And setting aside this identification does not interfere with the huge public policy in true exigency cases of police making not having their split second guessed.
But you agree that they could have. I mean, I know you're arguing they didn't have, and I think in part that seems to be what the ADA is arguing here, that they could have concluded whether it took moments to do that or not, that it would be either more or at least as suggestive to do it individually.
They could have, and since I'm here in a really unusual posture where I'm taking issue with an initial minimal burden,
Yes.
maybe that would have been enough, and it would have converted it then, it would have shifted to the defendant to ultimately prove and carry their burden of actual persuasion, which this court typically does not need to be involved with as a mixed question.
Right.
But I think we have a situation where we have so little offered by the prosecution, who are in control of all the facts and all the knowledge, and we have just no articulation of anything in the record. This is why it shifts from not police control, to exigency, to, oh, it's a logistical problem, oh, it would have been dangerous. The reason we're doing this and having these discussions is because there's no point in the record where we can point to and say, right there is where they at least tried to take a step or explain why they couldn't. And I think I'll just note before I sit down that it's hard to defend the integrity of an identification procedure when one officer at the suppression hearing refuses to admit the procedure even happened, when the second officer misidentifies the defendant at the procedure, when a statement notice is served on the wrong defendant, when the prosecutor at the Wade hearing can't even correct the record as to who the statement notice should go to, and then when at the trial the complainant, who's adamantly over and over and over described this person and is familiar with this person, misidentifies them too. So on that situation, we have a sincere risk of misidentification by association, and then a trial guilt by association. And that's why I think on this unusual posture, I think that this pretrial identification procedure should be suppressed and the indictment should be dismissed.
Thank you.
Thank you, Your Honors.